Mr. Teresi?
Good afternoon, Judge.
Good afternoon. Identified Mr. Stanziel, yourself, of course. Mr. Cubby is on the line. Mr. Cubby, can you hear me, sir?
Yes, I can. Can you hear me?
Yes, I can, sir.
Good.
And who's George?
That's a witness for the state, Judge.
All right. And I see a William Maybank. That's a police officer, correct?
That is a sergeant, yes, Judge.
Okay. Thank you. All right. Are we ready to proceed?
No, I don't think so, Your Honor. I had some questions about what we were proceeding on.
Well, okay. Just ready to proceed with the hearing. First, I'll read it to the record. This is a matter of state against David Cubby. Summons 2019, complaint number 4976. Charging a complaint with charge of criminal trespass, a petty disorderly persons offense, charged with resisting arrest, disorderly persons offense, and obstructing the administration of law or governmental function, a disorderly persons offense. Let's have a little history down on the record for this matter. This matter is summons were issued on this matter on November 2nd of 2019. The complaining officer was William Nybank. That's the sergeant that's on the screen now. There was various changes on February 21st, 2020. 3 months after the complaint was, the summons was served, there was a request for a change of venue from Patterson to Haledon, as defendant had filed a lawsuit against the city of Patterson.
We skipped a step in there, Your Honor.
I'm sorry?
We skipped a step in there, Your Honor.
What's the step I skipped?
They moved it up to county.
They moved it out of county?
They moved it up to county. They moved it up to the county court. They removed it to county court, which would have required a finding of probable cause and that the charges were aggravated to the point that it should have been promoted to the county level. But
well,
the
three charges looked like they're disorderly persons or petty disorderly persons offense. Well, that's the point I get to. You write in your letter to me recently that, well, I'll get to that in a minute, Mr. Cubby. Just hold on a second. Okay, Haledon scheduled this matter for April 1st, 2020. Due to the shutdown because of the coronavirus, it was rescheduled to May 29th. And I remember very clearly this is when the courts first started holding virtual hearings. Subsequently, it was rescheduled for June 30th, 2020. On June 30th, the defendant entered a not guilty plea, indicated he may apply for the public defender. An application was forwarded to the defendant, but never returned. Now, the defendant never requested discovery as per the rules of court at that point, but it was in fact sent out on July 14, 2020, and the case was rescheduled for July 28, 2020 for a status conference. On July 14, 2020, the defendant became uncooperative according to Haledon Court, and argumentative, and had to be removed from the session, and therefore they set it down for in-person trial on August 28th, 2020. According to the court record in Haledon, on August 28th, 2020, defendant failed to appear. Now, on November 20th, 2020, defendant contacted the court regarding a potential conflict with Judge Segreto regarding Judge Segreto's representation of a company and in a civil matter, nothing to do with this particular case. So I reviewed and changed a venue from Haledon to North Haledon, and it's at North Haledon now. January 25th was scheduled for a status conference, which we did hold. And on February 22nd, I was under the impression that Mr. Cubby was requesting a PC hearing. From his letter I received, dated February 24th, he does not want a probable cause hearing. Well, I reviewed that, and like I said I would, and I find that the complaint, the summons, and under Rule 7:2-2 of the New Jersey Rules of Court, the arresting officer had to file a certification, which he did, or the issuing officer. Judge Xavier Rodriguez of the Patterson Municipal Court reviewed the summons complaint, the law enforcement. Hold on the plea. We reviewed the plea, the preliminary law enforcement investigative report, and that was submitted by Officer Nyback, which is certified in accordance with Rule 7:2-2. He found that PC existed to believe an offense was committed, and the defendant committed it. He found probable cause, not a conviction. Okay? And that's why I find with regard to probable cause. There was a probable cause determination in accordance with the rules of court.
Your Honor, how can they make a probable cause determination when I wasn't present in court?
You don't have to be present in
I
court.
do have to be present in court because
If you're requesting a hearing, you will be present in court. But
right, but when they start moving things from the county and back down from the county and then out of town without any notice to me, that's them trying to stop me from getting a probable cause hearing for up to 6 months.
Mr. Cubby, probable cause was found by Judge Rodriguez in accordance with Rule 7:2.
No, I disagree. That's an ex parte hearing. It's an ex parte hearing.
No, you had 16,
Your
16.
Honor, I would like, before you continue, I would just like to say, if you're going to go down this path, what I'm going to say is you're just trying to further the wrongful acts of the court that had this before you. I'm not going to go down this path.
Mr. Cubby, I'll give you a chance to talk. I'm speaking now, okay? So when I get done speaking, I will give you a total opportunity to say what you need to say. I'm reviewing this matter from the get-go, okay?
And I find you just basically glossed over a dozen different things that I have to dispute.
Mr. Cubby, talk one more time when I'm talking. I'll give you a chance, I told you. I will give you a chance to say whatever you like to say.
You're rushing through this.
I'm not rushing through anything.
You are. There's about a dozen things that you've already stated that I'm going to have to contest because they're inaccurate.
Mr. Cubby, I will mute you if you continue to talk over me. Okay? You have a habit of doing this in court.
I understand your position, but I consider that a threat.
Oh, please. Mr. Cubby, guess what? Here's the deal. The probable cause hearing, you had several opportunities to do so, 6 times a period.
Wrong.
Okay, well, guess what? You think I'm wrong. I'm not.
And you won't let me have a fair hearing on it. You won't let me have a fair hearing on this. I'm leaving the session if you mute me.
Please mute
I'm leaving the session if you mute me.
Please mute
I'm leaving the session if you mute me.
You leave the session, I'll hold you in contempt, okay?
Hold me in contempt. I get a trial for that, right? A jury trial. Which is what they try to
deny me.
You're not a jury trial. Which is what the state county is trying to deny me in parallel matters.
Mr. Cubby, guess what? I deny, you want to appeal my decision. Probable cause was found by Judge. Probable cause was found. That's my ruling.
But you've been trying to stack these hearings in a way that you can find probable cause without having any recourse.
Spoliation has to do with a civil matter, okay? If you're contending that something is wrong with the tape, you received all the
discovery that you are purposefully trying to avoid it in these discussions.
Yeah, okay. I'm sorry, I disagree with you. You know what? Here's what we're doing. I'm setting this down for trial, Mr. Cubby.
Stop trying to rush me. Let's go over it. I want to go over it right now. We'll go over the whole record right now, tonight.
Okay, I will go over it if you keep your mouth in check while I'm speaking.
Well, I'm saying, well, you know what? I'm saying that you're trying to trigger me into speaking over you by saying stuff.
No, I'm not, Mr. Cubby. You speak over everyone.
Well, I have to make that assumption because you are ignoring relevant things, and I asked the court to address these previously. Hello?
Mr. Cubby?
Yes, I hear you.
Judge, are you there?
Mr. Cubby?
Yes.
What do you have to say about the fact that I found that a proper probable cause determination was made by Xavier Rodriguez, a judicial officer in the city of Patterson?
That there were at least, based on what you had already said before, there were at least a dozen things that I was trying to get this court to address, and I was trying to get your predecessors to address, which the court refused to address on numerous occasions.
What were they? Give me number one.
Well, let's go back to the beginning of your recitation of the facts of the case. I can stop you, or if you would allow me to. I didn't want to just interject and stop you in the middle of your recitation.
You did. Go ahead, Mr. Cubby.
Much deeper into it, and now you're trying to tell me that I interrupted you.
Mr. Cubby, please. Mr. Cubby, tell me what you'd like to tell me about this.
Well, beginning with the scheduling of the first hearing in Patterson on a Saturday, which is not a court date, then moving this matter up to county without a hearing, moving it back down after denying me a hearing. I asked for a hearing at the county level from the county prosecutor, who indicated to me that they were treating me as a victim and that they were looking into dismissing the matter, but could not dismiss the matter at the county level. which is a lie, because they could have found they could have made a probable cause hearing at the county level. I was completely misrepresented to me at the county level what they were doing with the case.
And what did you do about that?
I sent letters to the prosecutor on numerous occasions asking for hearings. They took months to get this thing scheduled in Patterson, and as soon as I walked in Patterson, the prosecutor there declared another conflict of interest and tried to have the thing moved out of Patterson. A prosecutor who I had no previous business with, or any that would have resulted in prejudice.
Did you file a lawsuit against the city of Patterson?
Yes.
Okay, that's the reason for the change of venue.
But that's not a valid reason for a change of venue.
Oh, yes, it is.
How is it a valid reason for a change of venue?
You are sitting in a city of Patterson where you're suing them, and the judge is paid by the city of Patterson. So that is a conflict. I get them all the time, and I actually signed a change of venue removal from that particular matter.
At the
Okay.
same time, the court wasn't interested in allowing me to make a motion to dismiss when I've been saying this entire time that by reviewing these reports, you can see that there's no probable cause in this case by comparing what the officer said.
Well, I
to allow me
reviewed.
to have that discussion.
I reviewed your complaint. I reviewed the officer's plea, and I would have found probable cause. It's not probable cause you're guilty. Probable cause that a offense was committed and that you committed it. That's all.
Do you want to you want to state your specifics on the elements of that offense? Because I mean, there's no way.
No, I'm not going to. I don't have to.
You
I don't have to.
And you're going to hide behind not having to. Is that what
I'm not hiding, Mr. Cubby. Mr. Cubby, listen. That's the first discussion, okay? So, number one, I find probable cause. All right? You're the one who mentioned
the
probable.
Behind the probable cause discussion here.
You're the one who mentioned the probable cause hearing that all of a sudden in your letter, you never asked for it and you don't want it. So you're not going to get one today. Second, what's your second question with regard to discovery? Did you receive all the discovery?
No. I haven't even been put in a position to make reasonable discovery requests.
Why not? You have a pen, you have a paper, write it,
I don't have
send it to the
prosecutor
prosecutor.
half the time this thing's been in front of a court. They keep moving it around without hearings.
Mr. Prosecutor, Stanziel, did you send or are you aware that Mr. Cubby has all relevant discovery in this matter that you are going to use to prosecute this matter?
Not irrelevant to the question.
I'm talking to Mr. Stanziel.
That's not relevant to the question.
I'm talking to Mr. Stanziel. After I get done with his answer.
That use is not all evidence. That's you're
Mr. Stanziel.
You're qualifying.
Judge, what I provided was what was provided to me from Patterson via email, and then subsequently received a video from George, who was on this video, on the Zoom, sent that UPS. That is the discovery I intend to use for this particular trial.
Is that a copy of the original?
I only have copies. That's as far
Of
as
the original tape?
this is what George produced for me. This is from the store that George owned. So they are copies.
George, what is your last name, sir? I can't hear you. Unmute yourself, sir.
Bagdasarov. B-A-G.
Thank you, sir.
Yeah.
Did you provide the police and the prosecutor with an original copy of the video from your store?
Correct. Several times already, yeah.
Okay, thank you. And you still have the original?
Correct. On my
Thank
computer.
you. Okay, Mr. Cubby.
Why hasn't anyone done anything to recover the 8 seconds of missing footage that's missing from the time signature of the video?
All right, I don't know anything about this, but...
Right, nobody knows anything about this, so we're just trying to create
Is there...
procedural...
All right, hold on.
This
Let me ask,
that
Mr.
no one
Cubby.
wants to answer for.
All right, Mr. Stanziel, did you determine why the claim of Mr. Cubby that there's essential missing footage from that video?
Judge, that has to be answered by George, which I would do at a preliminary hearing.
Okay, we'll have a preliminary.
It can't be answered by the guy that handed it over to him. It's got to be answered by the three people who did nothing to find the extra 8 seconds.
I'm not asking them.
6 months.
Well, I don't know about that. I'm trying to find out for you today, Mr. Cubby.
I can produce multiple letters about that footage and the fact that they haven't been forthcoming on where it's been, who had custody of it, and what they did with it.
I'm going to find out today for you. Okay, Mr. Let's see. Okay, that's one issue, the missing footage. What's your next issue?
multiple conflicting statements in the police reports. And at this point, we're getting into my mental impressions. My position is the prosecution has absolutely no belief in a probable cause here. So, I mean, if he's going to keep maintaining that there's probable cause here, anything that I do will be followed by sanctions at the conclusion of this. Because I believe within pointing out 4 things in the police report and comparing things with the video, I can knock this thing out just like that. But it's been
Wasn't it a matter of trial, Mr. Cubby?
Hold on. No, it's not a matter of trial. It's a matter
It's
of the
not?
state. Hang on. It's a matter of the state trying to create an illusion of probable cause in this matter to make these things look less severe than they actually are.
You have an officer sworn testimony on the clear.
And you have other officers whose testimony directly conflicts what he said. And you don't even have enough in his sworn testimony to go off.
That's your defense, sir. By the way,
But
Mr.
now,
Cubby,
15 months later, you're going to let him testify?
I'm going to let him
After I've
testify.
had to file stuff for 15 months, you're going to allow the state?
Yes, I'm
let
going
him
to, Mr.
testify?
Cubby. Yes, Mr. Cubby, I'm
Oh,
going
that's
to.
ridiculous. You know that's wrong.
Well, you can think
know
whatever
that's
you
wrong.
want,
I'm
Mr.
saying
Cubby.
you know that's wrong, and there's no rational legal conclusion you could lead to the other
Mr.
side.
Cubby, I have one more question. Do you have a recording on of this hearing?
Absolutely.
Good. You're in violation of the laws. I warned you before. I'm going to warn you right now.
You're wrong.
Turn it off.
You're wrong.
I told you under
I'm gonna
I told
post-
you under
I'm
Supreme
gonna post
Court
this to the internet. That's what I'm going to do. I'm gonna
the
put it on
Supreme
internet.
Court order, you got to get special permission to
No,
do
I
that.
don't. You're
Yes, you do,
deliberately
sir.
misinterpreting that rule, or you
Yes,
haven't read it.
you do,
You're
sir.
deliberately misrepresenting that rule, or you haven't read it.
Oh, I am? Really? Maybe you
Yes.
didn't read it, sir. I'm not going to argue with you, Mr. Cubby. All right, number
now you're
one,
gonna turn it
I
off,
find
right?
probable cause was issued properly.
And now you're going to
Number
just enter your
two,
order, and you're going to try to walk away like you checked off your boxes, right? Like
Yeah,
just
good
like
for-
the other 3 guys did, like you promised.
Yeah,
you were gonna
okay.
do, right?
yeah. By the way, Mr. Cubby,
I thought
you're a
so.
lawyer, right? You're an attorney?
Yeah, absolutely.
You're licensed in the state of New Jersey?
Well, actually, I'm suspended right now because the state of New Jersey doesn't like that I'm going after the city of Patterson.
Let me go one more step here. You know, you were previously advised of your right to counsel under the 6th Amendment.
I'm also
Okay.
I'm also advising you of my
Yeah,
right
right.
to just take this up with the press. I'm really done with you guys. I made a motion to dismiss last year.
Guess what?
Can I have interlocutory
making
appeal
another one?
for that?
You're
Can
making
I have an
another one?
interlocutory appeal for my motion to
Denied.
dismiss?
Your motion
Okay.
is denied.
Anything else
All
you want
right?
to do tonight then?
No, you get ready for trial.
I
The
don't
next
think
time
so.
it's listed. Yeah, well, I do.
I'm asking you to recuse yourself too.
I am not.
Okay.
Guess what, sir? I'm not. And guess what? If I find any that you've recorded this and it gets decimated in violation of the court order, the court rule, you are going to be held in contempt.
I'll make sure I put that up first.
I thought you would. All right, Mr. Cubby. Anything else? Would you like to hear from the witnesses today?
No, I believe that the court is deliberately trying to not have a hearing on the issues I put before it. You're deliberately
every
trying
court
to
is.
find ways to not discuss the issues that I brought up in my letters
What
and
is the
correspondence,
issue with
just
Mr.
like the
Cubby?
previous courts did.
I'm not having any more contact. I'm not having any more conversation with you. You're recording this
Right, because
conversation
the more you
in
say,
violation
the more you know
of my
that I'm
order.
getting you deeper
You
into the
violated
hole.
a court order. I told you last time. You've been told by other
What is
judges
the
on
public
the
policy
record.
behind that court order? What public policy does that court order serve, Your Honor?
Why don't you argue with the Supreme Court Justice?
No, I'm going to argue with you. What public policy does it serve besides trying to hide stuff?
I follow. The policy is what it's stated.
What does it say? Tell me what it says.
Where,
You
when
don't
to
want to
read
go
it.
over what the law says.
It's
You want to
collateral
just
issue. I'm not
say,
gonna-
you
guess
want to
what?
conclude. You want to conclude and move on.
Mr. Cubby, we're going to schedule this matter for trial. Mr. Stanziel, have all your witnesses ready.
I'm going to call
Okay?
this cowardly. That's how I'm going to describe this. Absolutely cowardly. I thought better of you. I did.
Mr. Cubby, I'm not here to argue with you, sir. I'm here to hear your case,
You
to
should probably
find out.
recuse yourself. You're not trying to hear my case. You're trying to hear what the
well, you're
state
gonna
wants
try to
put
do
on
it
the record.
again?
That's what you're trying to hear.
Mr. Cubby, you're trying to do it again to get me recused. It's not going to happen, sir. You're innocent until proven guilty beyond a reasonable doubt. Your collateral issues have no basis,
No,
none
yes, they
whatsoever.
do. They have absolute
Go to
basis.
trial,
You haven't
sir.
discussed them. You are
I
avoiding
suggest that you get your
substantive
own.
discussion on
I
those
suggest that
issues.
you get.
You're
you know, we
avoiding
can't have a
discussion on those
discussion
issues.
because you talk over everyone.
Because
Mr.
I
Cubby,
have to.
I would suggest that you get counsel
Because
to
I
represent
have
you
to.
better.
You are trying
Okay?
to stuff the record with false facts, so I have to
Yes.
speak over
Okay.
you. I would be entitled to speak over you in open court because you are trying to falsify.
And
the
you will be
record.
held in contempt in open court, sir. You know that.
I can be held in contempt right here.
I don't
As a
know where
matter
you
of
learned your
fact, I
courtroom
wanted the
manners
court to
from.
hold me in contempt in a
I don't know where you
parallel
learned your
matter,
courtroom
which
manners.
I believe that this is retaliation for. And they
Oh,
refused to
good.
hold
You
me
can
in
believe
contempt
anything
for it.
you want,
And they
sir.
filed a
Believe
court-
anything you want. Okay? We're going to try this case. I'm going to hear it. Okay? We have we have nothing. I don't
I
represent
will not
someone.
try this case in this court. I won't
You
do
won't
it.
try it anywhere. That's your problem.
No,
You don't want to
you're
try
right,
it
I won't,
anywhere.
because it should not be
You're
tried.
going to try
It
it,
should not
sir.
be tried, and you're using situations like this to hold it over people's heads and force them
Oh.
to your political will. That's basically what you're doing.
Oh, sure.
Well, hey, if
You
you,
believe
don't, if
that.
you don't want to see it, I'm telling you that's what's happening. So if you just want to
Okay.
force this thing to trial, it's on you,
You're in
right?
court
It's on
now.
you personally, your decision, right?
All right. One more
You
thing.
understand that, right? You're forcing this matter to trial.
I'm not forcing it. You've been avoiding trial
No, I'm
for the
not
last.
avoiding anything.
You are, sir.
You are trying
You are,
to
sir.
frame the discussion that is in a way that is.
Sir, all you
favorable to
have
the
is
state.
discussions with yourself about what you think is right. You get rulings against you. Appeal them. File an appeal.
How can I
Okay?
appeal a ruling that has
You
no
asked for an
substance to it?
interlocutory appeal
How
on
can
my
you
ruling
file an
today.
appeal to something with no substance to it? How can you be effective with your clients when you constantly have to file appeals because the judges know that you have to file an appeal?
Mr. Cubby, are you ready to proceed to trial?
No,
Why?
because there's no reason for this to go to trial and allowing
Well,
this,
I just gave you
hold
every
on,
reason.
hold
Probable
on,
cause was found.
hold
Go
on.
ahead. Go
Allowing
ahead.
this to go to trial will jeopardize the rights of people that these people oppress on a daily basis down there. It's not. You're telling me that you can do this to an attorney, and that a normal person can fend for themselves down there. You're gonna
defend
with a
that,
straight
sir.
face. With a straight face,
You have
you're gonna say that.
rights. You should learn what your rights are. You have the right to be represented by counsel. Do you want a lawyer to represent you?
Dismiss this matter, or that's.
I'm
my
not
final request to
dismissing
this
it,
court.
sir.
Dismiss it.
You can file whatever you need to
Right,
file.
and you're not- and you're-
I'm not
How
dismissing
much
this
arguing have I
matter.
done with the prosecutor here?
Are you ready to
How much
proceed
arguing
to
have I done with
trial?
the prosecutor here, and how much have I done with argued with the trier of fact who's shielding that prosecutor from having to say anything?
Shielding him?
Shielding him.
Mr. Stanziel, anything you'd like to say to Mr. Covey?
State is ready to proceed, Judge. If you like, we can have
Right,
the
that's an easy
preliminary
thing
hearing.
for a coward to say, just so he can check off the
Yeah,
box
keep
and try
talking
to
over
avoid
Mr.
personal
Covey.
liability.
Keep talking over
He's trying
everyone,
to check
Mr.
off his
Covey.
box and avoid personal liability by making a boilerplate statement on the record. That's what he's doing.
Okay, I'm ready to
I'm
proceed to
sorry.
trial
Are
this
you
matter.
not taking me seriously? Is there something funny about
All
this, Your Honor?
discovery issues have been resolved.
No, they have not.
Okay?
No, they
Mr.
have not.
Stanziel?
No, they have not.
Okay. Guess what?
I haven't
We're
had
gonna
discovery
try
on
this case.
because the case
We're
the
gonna
state
try
is
this
hiding the
case.
ball. I have not
Now, you
had
want to file an
discovery.
interlocutory appeal with regard to my rulings?
What?
Do you want to file an interlocutory appeal? Do you know what that means?
No, I'll just let you kick it down the road until eventually you end up in federal court. Go ahead.
Okay, good.
Trial.
Well, that's what you'll do next, of course, to get me recused. Like you do every other
You're not
judge, I
taking it
think.
seriously. You got a smile on your face. You're giggling the whole time.
Well, how can you see me? You're dark in there. Why can't you put yourself up on the screen?
Because I needed to record. I'd rather record it than actually have you.
Oh, Mr. Cubby, you're in violation. I'm holding you in contempt. I told you on 3 different occasions and twice today not to record this. You're in violation. I'm holding you
What
in
is your public
contempt.
policy reason for saying
Okay,
I
so
can't record
we'll
this
schedule you
lecture?
for a contempt hearing,
What is
sir.
your reason? What is your public policy reason
I
for holding
gave you a
me?
reason. I gave
What's
you
your
my
reason? What are you
reason multiple
enforcing? That you
occasions.
just-
I
you
wrote
don't
it in a
want me to
letter to you,
record this.
sir. All right, we're done with this hearing.
Besides you not wanting me to record this, what's your
Schedule
reason
this
for
for
saying I can't
trial.
record it?
Schedule
What
this
is
for
your reason
trial.
for saying that I can't record this besides you don't
Schedule
want me
it
to
in
record
for an in-person
What do
session.
you want? What is your reason for not allowing me to record this?
I told you once, I told you
No, you
twice, I
haven't.
told you
No,
3
you
times.
haven't. You made a general
Mr.
statement
Cubby?
with no substance to it.
Mr. Cubby, please. Mr. Cubby, I sent you a letter,
No,
and I
please.
gave you
No,
the.
please. Look, you can terminate this hearing anytime you want, but you want the last word on this stuff, right? You're just as interested.
Do you
as I
have
am,
the
right?
letter I sent you,
You
Mr.
threatened me
Cubby?
a half dozen times,
The
right?
letter, Mr. Cubby, you have the letter that I sent you?
I have letters that I was sent. I don't know what letter you're referring to.
Well, refer to the one that I sent you. I sent you 2, I believe. And one of them tells you the source to where to look. All right? And I stated on the record already.
And it doesn't say anything. It says
I'm not
nothing
stating it
about-
again.
It says guests to the courthouse. It has nothing to do with me sitting on the internet from my house at all. It has nothing. It's not even directed to members of the bar, for that matter.
You done?
Are you done just ignoring what I have to say and not actually?
No,
doing anything to
I'm
fund it?
telling you what my ruling is not to record this, and you keep recording.
And I'm telling you,
And I'm
that
not
your
going to be
ruling
in a
has no
session with you
substance.
recording
You're trying to
anymore.
avoid the point.
And I'm holding you in contempt. You're advised you're contempt. I suggest that you get an attorney to
I
represent
demand a
you.
jury trial.
You're not getting one.
What are your reasons for denying me a jury trial?
Because contempt hearing, they'll get a jury trial, Mr. Covey. Mr. Covey, where did you practice? Where did you go to law school? I don't understand where you're coming up with this from.
I get a jury trial, so you can't do what you're doing, which is to basically hold me in contempt to avoid the avoid any kind of responsibility for your holding.
All right,
And
Mr.
I'm
Cubby.
directly claiming that your contempt holding is in direct
Mr. Cubby.
retaliation for you not wanting to actually deal with this matter.
Guess what, Mr. Cubby? Next time, we will proceed with this matter of trial, okay? If you don't appear,
What about the contempt hearing? Then I'm accusing you of
I told you, I'll tell you when, I'll tell you
Well, you
when
have
the
a
contempt
conflict
hearing
because I'm
is.
saying your contempt hearing is completely bullshit.
Excuse, Mr. Cubby.
Oh, I'm sorry. Are you going to pretend you're
Sir,
offended
you
now?
do not
Are
use
you gonna
language
pretend
in
you're
my court,
offended
we're in the
now?
courtroom, sir.
Oh, you're going to pretend
Do
you're
not
offended now,
use
right?
any language.
Now you're going to ask
All right,
the
Mr.
OAE.
Cubby.
Now you're going to ask the OAE to write letters about me, right? To hold me up
Mr.
on charges
Cubby,
so that you
Mr.
can,
Cubby, I'm done with
open up
you.
another front of BS on this whole thing. Is that what you're going to try to
Mr.
do?
Teresi, please mute Mr. Cubby,
Oh,
and we'll
God.
schedule a contempt
You're
hearing.
a
Mr.
fraud and
Cubby,
a phony.
get yourself a lawyer, Mr. Cubby.
Bye. I'm leaving the session.
Done. All right.